I see Mr. Brockmeyer, you are in the courtroom, and Mr. DeLugo, we have you. We don't have video. Are you only appearing via audio and your mic is off? Oh, there you are.
Here I am.
DeLugo. Gotcha. Very good. So you're both in the virtual courtroom. Welcome. And we are ready, Mr. Brockmeyer, when you are.
Thank you, Your Honor. And may it please the court, Alex Brockmeyer on behalf of John and Elaine Dial. I would like to reserve 5 minutes for rebuttal.
Very good.
There are 3 issues on appeal. The first 2 concern Mrs. Dial and center around what I will generally refer to as the Jorg issue, which was the trial court's decision to preclude my client, Mrs. Dial, from entering into evidence the full amount that her medical providers charged her for past medical expenses, and instead limiting her to introducing into evidence the discounted amounts that her healthcare providers accepted from Medicare. And
just to be clear, you're not arguing that after the trial was over, the trial court couldn't have granted a remitter and reduce the actual damages to the amount that Medicare actually paid, correct? Your argument is strictly limited to the evidentiary aspect of the collateral source rule?
Absolutely, Your Honor. And Your Honor hits on a very important point, because the set-off issue is something that Jorg notes really harmonizes the evidentiary function of the collateral source rule and the damages function of the collateral source rule, which has been codified in 768.76. And what Jorg says when it recedes from Stanley is, look, Medicare is a collateral source. Whether past or future, Jorg says we don't view that as a relevant distinction. Medicare is a collateral source, and under the collateral source rule, under step 1, the full amount of the medical bills come into evidence, just like it would with private health care under this court's decision in Gold. Then we go to step 2, which is what Your Honor's question goes to, and we agree. Under step 2 of the analysis, the trial court post-trial would be able to consider a motion for set-off and would be able to reduce any past medical expenses award in the amount to what Medicare actually has a reimbursement or right for. So to really kind of understand this by way of, say, a hypothetical, let's say we have a past medical charge of $100. Medicare pays $20. That's accepted from the healthcare provider. That's what it has a right of reimbursement for. That right of reimbursement, that $20, that would not be subject to a set-off under section 768.76(2)(b), because that would be the benefit received from Medicare, which this court in its damages component of cooperative leasing says no set-off for. But what would be subject to a set-off would be the $80, because what cooperative leasing in footnote 1 of its opinion says is that write-off amount would be the amount paid for the benefit of the claimant under subsection 1 of 768.76, which is subject to a set-off. And that's how we harmonize both of the competing functions of the collateral source rule and prevent a plaintiff from, say, getting a windfall, which is what the damages component in cooperative leasing is concerned with, but at the same time, avoiding those inherent prejudices that the evidentiary collateral source rule concerns itself with.
Are you suggesting that cooperative leasing is strictly a damages function opinion?
Well, it certainly does have an evidentiary statement in there, Judge Lucas.
Well, yeah, I mean, in the holding, we say the trial court should have granted the appellant's motion in limine and prohibited Johnson from introducing the full amount of her medical bills into evidence.
And to understand that statement, we have to look at it in relation to the cases that it relied upon at that time, which were Stanley, which...
Okay, so to fast forward, your argument then, and I think you made this in your brief, is that how do you say it, Jorg?
Well,
Good luck.
I'm calling it George, but if you call it George or something else,
I'll call it George and
tomato,
recognize I'm probably wrong. But your argument in your brief and what I think I'm hearing you say is that, look, maybe we said that in cooperative leasing, but Georg has moved on and said that no, there is an evidentiary component to this, and that we would have gotten it wrong in cooperative leasing. And of course, the problem with that is that Georg actually cites cooperative leasing, but does not purport to abrogate or recede from the evidentiary part of the holding.
well, so yes, I'm saying that George receded from or implicitly abrogated cooperative leasing's evidentiary statement. And here's how we get there. Although George doesn't explicitly say we're overruling cooperative leasing, cooperative leasing relies on Stanley. It relied on the Illinois Supreme Court case Peterson, which was overruled subsequently in Wills. And George says we're receding from Stanley. Stanley was never meant to apply to Medicare, which was at issue in cooperative leasing. And then it also says we agree with the analysis set forth by the Illinois Supreme Court case in Wills, which overruled the Peterson case that cooperative leasing was relying upon. And so the interpretation of the evidentiary collateral source rule that cooperative leasing engaged in was really predicated on those two cases, Stanley and Peterson. The third case was ThyssenKrupp, which relied also on Peterson and Stanley. And so the underlying support for that rationale in cooperative leasing, the evidentiary support for that, has been abolished or abrogated by cooperative leasing, by George. And we see further support for that in the fact that earlier in the opinion, George cites in support of its contention that the district courts of appeal have said that Medicare is subject to the collateral source rule and should the discounted amount should be kept out. It cites the Winston Towers case out of the 3rd District, as well as the Valilla case out of the 4th District, both cases involving past Medicare expenses. Winston Towers was Medicare. Valilla was Medicaid. George says Medicare, Medicaid, it's all a collateral source. And so it really is showing that Medicare, George says this, Medicare is a collateral source, and that evidence of the discounted amounts paid from Medicare are inadmissible. That's why George said in its ultimate holding, we're reversing, it would have been error to admit the discounted amounts that Medicare would pay into evidence. I would also note that it's interesting that in the facts section of George, the court notes that at the trial court level, there was a motion in limine to preclude the discounted amounts that the plaintiff received from Medicare. It notes that the trial court granted the motion in limine as to that, and that this court affirmed the past medical expenses motion in limine in George, saying that the discounted amounts do not come into evidence and the plaintiff is entitled to board the full amount. And that's what we asked the trial court to do here. We asked the trial court to let us board the full amount and then consider post-trial any appropriate motions for set-off. That's the approach that George endorsed, and the trial court did not follow it here based on what we submit was an improper interpretation of the evidentiary collateral source rule. And the result of that was my clients had to suffer the inherently prejudicial effect of this collateral source evidence coming before the jury. Because as the Supreme Court has stated in Sheffield, George, Gormley, the evidence of these collateral sources coming into evidence is inherently prejudicial. And what really the effect of what my opponent wants to argue is, nonetheless, in light of George, that we're somehow going to treat, say, private health insurance under, say, Goebel differently than how we would treat Medicare. And what George tells us is that there is no relevant distinction there between, say, a private health insurance evidentiary issue in Goebel and a Medicare payment
Well,
And
I'll play devil's advocate. There is, and it's kind of a function of our health system, and to the extent it's a market, that you can say it's a market, but there is a distinction, because what the actual damages that are going to be incurred for those past medical expenses is a function of what the willing buyer, what the willing procurer, or the willing payor, and the willing provider agree to. And so if the healthcare provider accepts Medicare and Medicaid and accepts that as a fair rate of exchange, then that's the level of damages. It prevents what was described once as phantom damages from being recovered. Whereas if it's strictly a private insurance market, that's a different agreed upon amount. Admittedly, it doesn't appear to be the market rate of the actual end user of the services, but it is a reflection of value, and value that was accepted, which for purposes of what the amount of damages were for those past medical would I think would be relevant, wouldn't it?
Well, Your Honor hit on two things. First of all, you said damages, and the way that we, again, going back to George, harmonize the damages concerns with, not being able to recover, as you said, the phantom damages, is you deal with it through.
Those weren't my words, by the way. I'm just quoting them. But
I understand that, but that's what Goebel says. And the way Goebel says we deal with that is you file a motion for set off post-trial. And that's what George says as well. And it says that in the context of Medicare. Now, whether it's Medicare and the medical providers accepting a discounted amount from Medicare, it's the same thing with private health insurance. The private carriers have amounts that they agree with medical providers to accept. So I understand the distinction you're trying to make, but at the same token, that distinction can apply or can be said for private health insurance. And what Goebel has said is, for purposes of damages, there is more relevant evidence that the jury could hear other than the discounted amounts accepted from a healthcare provider for the reasonableness of the Medicare expenses. That's this court's decision in Goebel that says that. You can cross-examine the plaintiff on the necessity of the medical expense. You could bring in some sort of medical coding expert to say, this wasn't what say a shoulder surgery should cost, because you can do it cheaper on the private market. But that wasn't what was argued here. This was all just an issue of cooperative leasing says the discounted amounts come in because of Stanley and Peterson. And what has happened since then, a lot's changed. George's come out since cooperative leasing. I get that.
So this goes full circle. I think I hear you asking us to formally recognize that George implied, you use your words, implicitly abrogated that part of the holding of cooperative leasing, and you want us to now recede from that statement, because the statement of cooperative leasing is pretty unequivocal, and it cuts against you. And the only way to grant you relief is for us to recede from that part of cooperative.
Yeah, and that's what we're asking this court to do. Since cooperative leasing, there's been a subsequent Supreme Court decision that has eroded and abrogated the underlying Supreme Court precedent this court relied upon. We have a new Supreme Court case on this very issue, and that Supreme Court case says that, with the most due respect, the law has changed and that Medicare now is a collateral source, and it falls within the scope of the evidentiary collateral source rule, which says.
Mr. Brockmeyer, am I remembering correctly that the court actually cited to our case in their opinion?
You're correct, Your Honor.
And they had the opportunity to say something, but they chose not to, correct?
You're right, Your Honor. And the argument.
Which does create, as you know, I was on the panel of the underlying case. And so I appreciate the argument, but I am concerned about reading more into the Supreme Court opinion than what they said. And perhaps more significantly, when they mentioned our case, they could have said something to indicate it's no longer viable, and they chose not to for whatever reason.
Well, again, Your Honor, when George was discussing the evidentiary issue, it was discussing it in light of Stanley, which if Stanley's gone, then the support for cooperative leasing is gone from it as well. So I understand your concern, but at the same time, when the court was really considering this evidentiary issue, it was considering it in light of a a higher court opinion, its own opinion, in Stanley. And, you know, when the Supreme Court support for this court's decision in cooperative leasing no longer exists, and it's been removed and receded from, and says that Medicare is a collateral source, and that therefore the discounted amounts don't come into evidence, that I don't know how there's really any other way to reconcile this court's statement in cooperative leasing with Jorg, other than to just say, well, cooperative leasing was a past medical expenses case, Jorg was a future medical expenses case, but that distinction, in Jorg's own words in footnote 7, is an irrelevant one.
Let me interrupt you, because you're now going into the rebuttal time. I'm going to give you a couple more minutes because we've asked you a lot of questions on the one issue. I do want you to tell me or explain to us what evidence was there in opposition to the consortium claim.
The evidence in opposition to the consortium claim mainly was focused on a broader time removed from the accident, a couple years after the accident, where Mrs. and Mr. Dial went on a cruise, and they went and traveled up to New Jersey.
And the consortium claim may have been well, there are a couple things. One is the plaintiff did not ask for a specific amount of consortium. So to the extent that there was a period of time right after the injury, and if I remember correctly, it was something like 7, 8, 9 months that he said he had to help her with everything relating to daily living. Why is there not some error in the jury failing to award something? And so my question really is, was there any evidence contradicting the testimony that at least for some period of time, the spouse provided significant help to the plaintiff?
No, Your Honor. And in fact, Calusa Palms in fact stipulated that in the immediate after fact of this accident, Ms. Dial could not do her household chores.
And your argument basically is, well, maybe the jury decided the husband should provide these services out of an abundance of love for his wife. But is that the test?
Well, that's what Calusa Palms is arguing. I'm saying...
I'm sorry, I apologize, yes. But, and so my point to you is, you don't ask for an amount, but they take this position that, well, it's out of love. So is there any case that supports a total denial? And I think your answer is no, but I also don't see anything specific where in this case, you don't suggest, your client didn't suggest to the jury some amount that should have been awarded at all. And so was the jury potentially free to say they're not asking for anything? In fact, reading your closing argument didn't really talk very much at all about loss of consortium. So can we fault the jury for not awarding something under those circumstances?
We can, Your Honor. And in closing argument, trial counsel, although they did not give a specific number, did ask the jury to give Mr. Dial an acknowledgement on his consortium claim, give him at least something, which I would say is synonymous with saying give him a nominal sum of damages. And, you know, to do otherwise, to say, you know, jury, give Mr. Dial $100,000 or something to that effect, right, would really be just saying my trial counsel and Mr. Dial has to burn their credibility with the jury by asking for a large sum of damages. But
well, it didn't stop them from asking for a large sum in compensatory and medicals and so forth. So
well, it's a different claim.
It is, to some degree, it's a little puzzling, but we're at the end of your time. I'm going to go ahead and give you your 5 minutes for rebuttal if you're prepared to sit down or
I will mute myself and wait my turn to talk again.
Very good. Mr. DeLugo, you'll have a couple of extra minutes as well.
Thank you, Your Honor. May it please the court, my name is Michael DeLugo with the law firm of Wicker Smith in Orlando. I apologize, I'm not necessarily looking directly into the camera because the screen shifted when I was brought into the virtual courtroom, and so I didn't want to mess with the camera, so I apologize.
Mr. DeLugo, I don't want to take you off your argument, but I would like to address the last point that I just raised, which is, you know, you're saying that the jury could have just awarded nothing based on his love for his wife. Is that an appropriate measure?
Well, the main argument on the loss of consortium claim, and yes, we did make that argument as well, but what the Dials are asking for is for this court to serve as a seventh juror. Now, the jurors heard all the evidence, they got the instruction, they were told exactly what the law was, they heard all the testimony, and they made their decision. And I don't think there was anything inappropriate about the decision that they made. It was within their right to reach that conclusion.
Don't courts do that in the context of additors and remitters and other circumstances?
Sure, yes, they do. I mean, there's specific
So
statutory provisions.
why is it a winning argument to say that a court cannot sit as a seventh juror when the law allows a court to do exactly that in certain circumstances?
In certain circumstances which do not apply here. I think that the facts that were elicited during the course of testimony, during the course of trial, were such that the jury would be within its right to reach the conclusion that this is not something that would be a compensable event. Yes, Mr. Dial did provide things for his wife, and the jury could have reached the conclusion that he did so out of his love for her, and reached the conclusion that that is not a compensable event. And I don't believe it's the function of the court to invade that.
The law does say that helping with daily activities is a compensable event, correct?
Yes, there are cases that say that.
Okay. Okay, and you can go back. That's what I wanted to check with you.
Okay. May I go back to the main?
You can proceed.
Thank you. The problem, and I think that the court has recognized this, the problem with the main argument that the Dials are presenting is that the Dials are asking this court to conclude that the trial court abused its discretion by following this court's cooperative leasing opinion. And I think that the quote that Judge Lucas provided at the beginning of the Dials presentation is right on point. There's another quote from the case, from the beginning of the case, which says, and I quote, "Appellants contend that the trial court erred in allowing Johnson to admit into evidence bills for medical expenses for which she never incurred liability, and in allowing her to recover an amount in excess of benefits paid by Medicare as an element of compensatory damages. We agree and reverse." So the trial court did exactly what this court directed it to do in cooperative leasing. And so it cannot possibly be an abuse of discretion to follow this court's precedent. I'm also not familiar with the phrase that was used during the course of the Dials presentation of something along the lines of, I may not be quoting it exactly, but the concept of implicit abrogation. I'm not familiar with that as a legal concept. I would strongly dispute that the Jorg decision acts as a repeal of this court's cooperative leasing decision. In fact, as Judge Silverman, you pointed out, the Jorg court cited to cooperative leasing favorably. So it didn't have, it had the opportunity to say that cooperative leasing was decided incorrectly, and it decided not to do so. So we contend that the cooperative leasing approach to the introduction of evidence of Medicare payments is the appropriate approach. It was the same approach that the 4th District issued in ThyssenKrupp. And in fact, I submitted a notice of supplemental authority earlier this week. There was another decision out of the 4th which had reached the same conclusion, and that was just released on June 10th. So that cooperative leasing is just as viable in 2020 as it was when it was released in 2004. The legislature has been aware of the cooperative leasing decision for the 16 years since it was released, and it has done nothing to change the language of 768.76, which says in part, quote, "Medicare shall not be considered a collateral source." So the legislature had the opportunity, they've had 16 years to absorb the cooperative leasing decision and to change it, and they haven't. The decision as to treating Medicare differently than private insurance is, I think, a legislative one. The legislature has weighed in on this issue, and they haven't changed the law since the 768.76 was passed in the early 90s. So they've had an abundance of time to address this issue. They have chosen not to. The Jorg decision does not, as the Dials argue, abrogate the cooperative leasing case. I don't think this court is able to rule that the trial court abused its discretion by following this court's precedent. And so we believe that that issue should be affirmed. There is a cross appeal in this case, and I would like to address the issues raised in our cross appeal, if I may, unless the court has any further questions with regard to our cooperative leasing argument. The cross appeal has to do with the absence of definitive testimony as to where Ms. Dial fell. She was able to testify where she ended up, but she was not able to testify as to where she fell. She did not know exactly where she fell, on what part of the sidewalk. She had to return 2 days later to try to figure out where she fell, but she was never able to specifically identify where she fell. The Dials presented the testimony of an expert. I'm going to pronounce that improperly, probably Dr. Hejlar, who testified that any change in elevation of greater than 1/4 of an inch constitutes a dangerous condition. But Dr. Hejlar has no understanding of exactly where Ms. Dial fell. Ms. Dial doesn't know where she fell. She can't testify as to where she fell. Dr. Hejlar not only has never been to Caluso Palms, he has never spoken with Ms. Dial. He didn't even read her deposition. He read a summary of her deposition. So what the jury was left with was, yes, in the abstract, there is this concept of a dangerous condition, but we don't know where she fell, so we don't know whether there was a dangerous condition that caused her to fall. And the only way the jury could find liability would be to stack inferences. The first inference being that, identifying where Ms. Dial fell, and the second inference being that where she fell constituted a dangerous condition. And so in the absence of any testimony connecting those dots, they were left to stack inferences, and courts throughout the state of Florida have routinely found that that is insufficient to avoid a directed verdict on liability. And so on our cross appeal, we would ask that this court remand and with instructions to enter a final judgment in favor of Caluso Palms. And with that, I don't have any further argument to present unless the court has any questions for me.
Thank you, Mr. Belugo. Mr. Brockmeyer, you'll have your 5 minutes for rebuttal.
Thank you, Your Honor. Regarding the collateral source issue, when cooperative leasing was cited by George, it was always cited in the context of the damages analysis of that opinion. And again, when the court is receding from Stanley and its evidentiary component, with it comes any case that is relying on that Supreme Court opinion. So in that respect, the underlying evidentiary component of cooperative leasing has been abrogated. We're going to the cross appeal. Dr. Hejlar testified that anything over 1/4 of an inch in sidewalk elevation was dangerous. Exhibits 10 and 5-2 both show the slab that Ms. Dial tripped over, and both show that this slab was higher than 1/4 inch in elevation. In fact, when looking at exhibit 5-2, Ms. Dial testified, that's the sidewalk slab I tripped over. Ms. Dial unequivocally said that I tripped over an elevated slab that caused me to then stumble and fall forward into the bushes. There is no inference stacking that needs to occur here. We know what the dangerous condition is. We know that Ms. Dial, which is the elevated slab over 1/4 inch, we have Ms. Dial's testimony that she tripped over the elevated slab. We have photographic evidence showing the slab and showing that it's over 1/4 inch in elevation. And then Ms. Dial saying that after I tripped on the slab, I stumbled forward and fell into the bushes, thereby breaking my arm. So when we look at this in light of the standard of review that we have for a directed verdict motion, which is what Caluso Palms is cross appealing, and resolving the evidence in the light most favorable to Mrs. Dial, the trial court did correctly deny the motion for directed verdict. My opponent mentioned some issues regarding Dr. Hejlar, what he did or did not review. That's all evidence that the jury can consider and weigh, but that's all that really comes down to is the weight of the evidence that the jury can afford to those, what it wants to call the discrepancies in Dr. Keslar's testimony. That's not enough to take this question away from the jury on something that it ultimately found in my client's favor on. And so with that being said, we would ask that this court on the Dial's appeal reverse for Mrs. Dial and remand for a new trial on damages or damages and liability. For Mr. Dial, reverse and remand for a new trial on the consortium claim, and then affirm on the directed verdict.
Very good. Thank you, Mr. Brockmeyer. Mr. DeLugo, if you want to make a few comments in reply to the cross appeal, you may. If not, then that's fine too.
Thank you, Your Honor. I will rest on the briefs.
Very good. Thank you both very much. And that will conclude this argument. So you may leave.